Support for This One Time in Kankakee comes from Raven Spring Media, where method, media, and mindfulness create impact. From video production, photography, animation, and team building, Raven Spring Media creates compelling content that captures your brand's unique story in a strategic way. With over 20 years of visual storytelling experience, Raven Spring Media brings together creative expertise and a fresh perspective to every project they undertake. Begin your story today at ravenspringmedia.com. Support for This One Time in Kankakee comes from the Kankakee Area YMCA. The Kankakee Area YMCA is more than just a gym. It's a movement of thousands of people making positive changes in their lives and their community. The YMCA is Kankakee's premier provider of family health and wellness. Become a Y member today at their location on Kennedy Drive in Kankakee or at k3ymca.org. For youth development, for healthy living, for social responsibility. The Kankakee Area YMCA. This one time in Kankakee, the county sheriff was arrested. Welcome to This One Time in Kankakee on the WVLI Podcast Network. I'm Jake LaMore. Today we take a look back at November 1961. It's a chapter in local history involving a significant legal standoff and a complex constitutional question regarding Kankakee County's highest law enforcement office. This episode is based on the archival documentation of the Kankakee County Museum, originally compiled by local historian Jack Klasey. The timeline begins on Friday afternoon, November 3rd, 1961. On that afternoon, a legal proceeding took place inside the private chambers of Circuit Judge Victor Cardosi at the Kankakee County Courthouse. The person named in the warrant was Kankakee County Sheriff Carl McNutt. Because the situation involved arresting a sitting sheriff, the duty fell to a specific county official designated by Illinois law for such an overlap of authority, County Coroner Dr. Claire Sledge. Assisted by 2 Illinois state troopers, Dr. Sledge served Sheriff McNutt with an arrest warrant based on 13 separate grand jury indictments. The charges returned by the grand jury were diverse. 2 indictments charged McNutt with official misconduct, alleging that he used jail prisoners as drivers on personal overnight trips to other states. 2 additional indictments charged the sheriff with permitting the escape of prisoners, stating that 2 individuals had been released from jail before serving their full 30-day sentences. 8 indictments alleged the sheriff made unlawful financial claims for reimbursement on trips to various cities, and the final, 13th indictment, alleged a broader conspiracy.
The conspiracy indictment alleged that Sheriff McNutt and 6 other defendants had conspired beginning in 1960 to keep disorderly houses in Pembroke Township and rural moments.
The other co-defendants named in the paperwork were Aaron Greenlee, Lee Caldwell, Joan Bird, Rebecca Jackson, Teslar Gibbs, and Margaret Patton. Along with the 13 indictments, the grand jury recommended the sheriff voluntarily suspend himself from office until the charges were resolved. Sheriff McNutt declined, announcing that he would remain in office until the end of his term in December 1962. This created an unprecedented situation for local government. The Kankakee County Board of Supervisors sought a legal opinion on how to proceed with removing an elected official. On November 14th, State's Attorney Edward Drolet advised the board on the limits of their statutory power.
To the Board of Supervisors. This board has no legal authority to conduct impeachment proceedings against an elected county officer. Under state law, a county office cannot be declared vacant until the holder is officially convicted of a crime.
Citing what he termed a breakdown in law and order, Drolet issued a formal 24-hour ultimatum to Sheriff McNutt on November 20th, giving him the opportunity to consider offering his resignation. Following McNutt's refusal, Drolet took the step of asking the state government to intervene, contacting Illinois State Police Superintendent William H. Morris.
Superintendent Morris, I request that you assign me a sufficient number of officers on continuous call to supersede the local police authority to exercise full police power in Kankakee County in order that law and order may be enforced.
2 days later, the local press reported that the request had been granted.
The Journal, November 22, 1961. State police today were ordered to give all the aid needed to enforce law and order in Kankakee County. The newspaper observed that the assignment of state police to enforce the law in place of a sheriff is unprecedented in Illinois history.
By December, the local judicial system faced its own logistical challenges. 3 local circuit judges, Victor Cardosi of Kankakee, David Oram of Watseka, and James Bartley of Joliet, all disqualified themselves from the case. To avoid potential conflicts of interest, the court administrator of the Illinois Supreme Court assigned an outside official, Circuit Judge Albert O'Sullivan from Belvedere, to preside over the future proceedings. Judge O'Sullivan's first significant ruling came on January 3, 1962, when he denied motions by the defense to void the 12 indictments naming only McNutt. However, 2 weeks later, on January 17th, Judge O'Sullivan ruled differently on the conspiracy indictment involving the other 6 defendants. McNutt's defense attorneys, led by Wayne Dyer, argued that the indictment was legally invalid because a conspiracy conviction carried a greater statutory penalty than the actual commission of the underlying crime itself. Judge O'Sullivan agreed with the defense and dismissed the conspiracy charge.
In quashing the indictment, O'Sullivan released the other defendants from arrest. McNutt still must stand trial on 12 other indictments returned by the grand jury.
The first of the 12 trials began on Monday, February 5, 1962, before a jury of 7 women and 5 men. The state chose to proceed first on the charge of allowing a prisoner to escape by early release. After 2 days of testimony and closing arguments, the jury began its deliberations on Tuesday afternoon. Following 8 hours of deliberation and 11 separate ballots, the jury returned a verdict of not guilty. McNutt's attorney, Wayne Dyer, provided a brief statement to the press on the courthouse steps.
Yes, we are very happy about the verdict.
Exactly 1 month later, on March 5, 1962, McNutt returned to the court for the second trial regarding the remaining escape indictments. However, the proceeding took an unexpected turn before testimony began.
In a surprise move in Kankakee Circuit Court, Sheriff Carl McNutt pleaded guilty to 2 indictments charging him with misconduct.
The charges of which McNutt entered a guilty plea involved the use of jail inmates as drivers for overnight out-of-state trips. As a direct result of this plea, the state agreed to dismiss the remaining 10 indictments. And on Wednesday, March 7th, Judge O'Sullivan announced the final sentence.
The term of Carl R. McNutt as Sheriff of Kankakee County will end by March 21st as a result of action early this afternoon in Kankakee Circuit Court. McNutt was removed from office on the order of Judge Albert O'Sullivan. O'Sullivan also assessed a $1,000 fine.
On the morning of March 21, 1962, the Kankakee County Board of Supervisors held a special session to officially declare the office of sheriff vacant. To ensure continuity, the supervisors appointed Y.L. Marcotte, a retired electrical contractor, to serve as acting sheriff until the expiration of McNutt's original elective term in December. Following his removal from office, Carl McNutt returned to private life. His name appeared in the local record one last time less than 3 years later. On November 16, 1964, the Kankakee Daily Journal published his obituary.
Carl R. McNutt, 41 of Park Avenue, Bradley. Died Sunday afternoon at his home following a lingering illness.
He was buried in Mount Calvary Cemetery. The story of Carl McNutt remains a distinct chapter in the legal history of Kankakee County, an event that tested the boundaries of local authority, drew unprecedented state intervention, and ultimately resolved through the standard mechanics of the judicial system. This One Time in Kankakee is a production of the WVLI Podcast Network. Our voice cast for this episode featured Mike Tamano as the Daily Journal reporter, Rob West as State's Attorney Edward Drolet, and Denny Case as Defense Attorney Wayne Dyer. We extend our sincere thanks to the Kankakee County Museum for preserving the records that made this episode possible. Located in Governor Small Memorial Park in Kankakee, the museum has been the steadfast keeper of our region's rich history since 1906. From their extensive historical and genealogical archives to their rotating exhibits and historic structures, the museum offers an invaluable window into the people and stories that define our community. We highly encourage our listeners to visit, support their work, and explore Kankakee's history firsthand. We also acknowledge the endearing work of the late Jack Klasey, whose dedication to documenting our local history ensures these narratives continue to be told. I'm your host, Jake LaMore. Thank you so much for listening. If you have a story to share, shoot me an email at jake@milnermediapartners.com and finish this sentence for me. This one time in Kankakee. Listen to all of today's local news in one place.
Checking your WVLI news, I'm Rob West.
The WVLI News Update brings you the day's news in 10 minutes or less. Clear, credible, and on your schedule. Follow now wherever you get your podcasts or at WVLI927.com and click on air. It's all part of the new WVLI Podcast Network. The voices you trust beyond the dial.